Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. Now, the paperwork that you have on that clipboard, I'm going to go over that paperwork with you in a few minutes. Now, hold on a minute. Again, good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. As I mentioned earlier, the paperwork that you have, I'm going to go over that paperwork with you in a few minutes. You have been asked to come to court this morning for what we call an arraignment. An arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Hey, ladies and gentlemen, you have been asked to come to court for what is called an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have in this court is a criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are normally referred to as your most serious type of offenses, whereas your misdemeanors are normally referred to as petty offenses. It doesn't mean that they are not serious. It just means that they're not as serious as a felony case. And what I mean about when I say use the word serious, I'm talking about the facts of the offense as well as the punishment. For example, felonies are divided into 5 categories. You have a capital murder, first-degree felony, second-degree felony, third-degree felony, or a state jail felony. If you're convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, a fine up to $10,000. If you're convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine up to $10,000. If you're convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years and a fine up to $10,000. If you're convicted of a first-degree felony, the range of punishment is minimum 5 years in the state penitentiary to a maximum of 99 years to life and a fine up to $10,000. Now, if you are convicted of a capital murder, which is the highest felony, the range of punishment is life without parole in the state penitentiary or death by lethal injection. The misdemeanor cases are divided into 3 categories. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If you're convicted of a Class C misdemeanor, the range of punishment is by fine only. Cannot be given any jail time, you only can be given a fine. Now, however, if you do not pay your fine, then your fine can be converted to community service. If you do not perform the community service, then they can issue what is called a capers pro fine, which means a warrant for you to serve out a warrant to pay the fine. If you can't pay the fine, then you will serve jail time to serve it out. Now, the other type of misdemeanor is a Class B misdemeanor. For a Class B misdemeanor, the range of punishment is minimum 6 months to a maximum, range of punishment is 0 days to a maximum of 6 months, which is 180 days in the county jail, a fine from $0 to $2,000, or you can be given both such fine and confinement. The range of punishment for a Class A misdemeanor, if you're convicted, is minimum 0 days to maximum 1 year in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, the charge that you have in here, the offense that you have in here, is a misdemeanor case. We do not handle felony cases. So your offense will either be a Class A or Class B, and if your case was appealed from city court or JP court, it's a Class C misdemeanor. Now, you may get what we call probation. Now, what probation is, that basically means you will not be serving any jail time on your charge. You'll be out on probation. There are 2 types of probation. One type of probation is known as deferred adjudicated probation. What that basically means is you will not be given a conviction. You'll be placed on probation. And if you successfully complete the probation, then the case will be dismissed. And once the case is dismissed, you may qualify for a non-disclosure. What a non-disclosure is, it basically means that we cannot disclose the fact that you were on deferred adjudicated probation for this offense to the general public. Now, there are certain agencies that will be able to get a copy or get notice that you are or that you had deferred adjudicated probation. Now, the other type of probation is known as, we call it regular probation. With the regular probation, it does result in a conviction on your record. Now, however, you may qualify for what we call judicial clemency. And what judicial clemency is, the court can set aside the conviction. And what set aside means, the court can, if you are convicted, the court can set aside that conviction. And the way it works is you have to successfully complete the probation. You can't have any more time left on your probation. And your probation, you have to be discharged from probation. If those 3 things happen and the court feels as though that you're a good candidate for the judicial clemency, then your conviction could be set aside. It could be wiped off or deleted from your record. Now, however, if you get a subsequent conviction, that means you get another conviction later on, then this conviction can be revived, resurrected, or brought back up, and it could be used against you in a case. And so if you try to get a license with CPS, Child Protective Services, or if you have a license with CPS, Child Protective Services, they can revoke your license, they can suspend your license, or if you're trying to get a license, they can deny giving you a license with that agency. Now, as a defendant in a criminal case, you have rights. One of the rights that you have is the right to have an attorney. The paperwork that you have on that clipboard talks about your right to have an attorney. The first document is titled Judge's Explanation to Defendants Without Attorney. And it states as follows: as a defendant in a criminal case, you have three options that's regarding your right to have an attorney. Number one, you may hire an attorney. Number two, you may hold on a minute, Mr. Galvin. Okay, so as I mentioned earlier, you have a right to have an attorney. You could either hire an attorney. If you can't afford to hire an attorney, you may see if you qualify for a court-appointed attorney, or you may waive your right to an attorney, give up your right to have an attorney and represent yourself. That's the third option. Now, if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset. Reset means you'll be given another court date. It'll be rescheduled to give you time to hire your attorney. If you want an attorney and do not have enough money to hire an attorney, you would need to fill out a financial questionnaire. The financial questionnaire is the document that is on the clipboard that is titled Jefferson County Affidavit of Indigence. Now, once you fill out that financial questionnaire, you'll fill it out so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you want to waive your right to have an attorney or give up your right to have an attorney, then if you want to speak to the prosecutor about your case, the prosecutor is assistant district attorney. You cannot speak to the prosecutor about your case unless you first sign a written waiver of your right to be represented by an attorney. Now, the written waiver is the second page on that document that's titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Now, once you sign that document, or once you sign the first two documents indicating that you want to waive your right to have an attorney, then you'll sign the second document that says Waiver of Counsel. Now, at the bottom of that document, the second paragraph, well, there's the fourth paragraph, it states, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunity relating to military service, possession of firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to proceed without an attorney, that is, if you decide that you would like to waive your right to have an attorney and represent yourself, and you can change your mind at any time. And if you change your mind, then you can request that an attorney be appointed to represent you. At the bottom of that document, in bold letters, it states defendant's choice, mark initials next to only one choice. If your choice is to hire your own attorney, then you will put your initials on the first line to the left. If you have already hired an attorney to represent you in this case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to see if you can qualify for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney in your case, then you will place your initials on the fourth line to the left. Now, if your choice is to represent yourself, that is to waive your right to an attorney and represent yourself, then you'll place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, Then you will sign your name on the line that is titled defendant, and you will date it today's date, June 13th of 2023. Now, for those of you who'll be waiving your right to an attorney and representing yourself, as I mentioned earlier, you would have to read and sign the document that is on the second page of the clipboard that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 13th day of June of 2023 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will place your initials on the line that is titled defendant, and you will date it today's date, June 6th of June 13th of 2023. Now, as a defendant in a criminal case, you have other rights. You have rights that extends beyond your right to have an attorney. One other right that you have is the right to have a jury trial. Where those young people are sitting in that area, we call that the jury box. Basically what that means is that's where the jury will be seated. 6 citizens from Jefferson County will be selected as the jury in your case. They will listen to all of the evidence. And after listening to all of the evidence in the closing arguments of the attorneys, they will deliberate. They will decide whether or not to find you guilty or not guilty. You also have a right to waive your right to have a jury trial. You have a right to give up your right to have a jury trial. And if you give up your right or waive your right to have a jury trial, then your case will come before the court or before the judge in one of 3 ways. One way it can come before the judge is by way of a bench trial. What a bench trial is judge by judge. It's a trial by judge only. The judge will listen to all of the evidence, and after listening to all of the evidence and the closing arguments, the judge will decide whether or not to find you guilty or not guilty. The other way that your case will come before the court is by way of an agreed plea bargain. An agreed plea bargain basically means that you and the district attorney have reached an agreement to settle your case. That is, you're pleading either guilty or no contest, and y'all reached an agreement to settle your case. And if you plead guilty, you're telling the court that you committed the offense that you've been charged with. If you're in a plea of no contest, you're telling the court that you will not be fighting or you will not be contesting those charges. So if you're in a plea of guilty or no contest, you and the state have reached an agreement. We call that an agreed plea bargain. Then it will come before the court. The court can either accept or reject your plea bargain agreement. If the court accepts your plea bargain agreement, and if you decide later on that, when I say later on, within 30 days, you decide within 30 days that I want to appeal my case. I want to have a higher court to look at my case because I think I've been wrongfully convicted or the court committed an error by convicting me. And if that's your choice, then you have to get permission from the judge to appeal your case, the judge who followed the plea bargain agreement. Now, if the judge gives you permission to appeal your case will go upstairs to the Ninth Court of Appeals. They will decide to grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeals, located in Austin, Texas. Now, you would have to file what is called a pro se petition for discretionary review. Pro se means you'll be filing this petition without an attorney. You'll be representing yourself. That's what we call pro se. You're representing yourself. And the Texas Court of Criminal Appeals, they can either accept or reject your pro se petition. If they accept your pro se petition, then they can simply find you not guilty. Or they can send the case back down to this court or the Court of Criminal Appeals, order us to give you a whole new trial, or order the Court of Criminal Appeals to look at some other issue that was unresolved. Now, if they deny your petition, then at that point, your conviction will stand. Now, so once your case, as I mentioned earlier, it can come before the judge by way of a bench trial or by way of an agreed plea bargain agreement. The other way it can come before the judge is by way of an unagreed plea bargain agreement. What that means is this here: you and the state have not been able to reach an agreement on your case. So you want the judge to settle. You want the judge to decide what your punishment is going to be. And so we call that an unagreed plea bargain agreement. At that point, you don't know what the court is going to, what the punishment is going to be. The judge can give you a punishment anywhere within the punishment range. So for example, for the class A misdemeanor, it's anywhere from 0 days to 365 days, a fine from $0 to $4,000, or both such fine and confinement, or the judge may give you probation. If it's a class B misdemeanor, range of punishment, 0 days to 180 days, which is 6 months in the county jail, a fine from $0 to $2,000. You could be given both such fine and confinement, or you may be out. And you may be eligible for the judge to give you probation. The judge can give you probation. Now, the other rights that you have, besides your right to have an attorney, besides your right to have a trial by jury, or your right to have a bench trial, a plea bargain agreement, or unagreed plea bargain agreement, you have a right to have witnesses to come to court. That area that I just pointed at, where that microphone is, we call that the witness stand. And what witnesses do, they will testify in your case. They can testify for you, against you. And if you're representing yourself, or if you have an attorney representing you, they can be asked questions. We either call it direct examination or cross-examination. So your attorney can ask questions if you're represented by an attorney, or you can ask the witness questions if you're representing yourself. Now, you can waive or give up your right to have witnesses that come to court. And what that means is that you will not be calling witnesses. It does not mean that the state will not be calling witnesses. The state, I'm talking about the district attorney's office. They will be calling witnesses in the case. Now, you also have a Fifth Amendment right against self-incrimination. What that means is you have a right not to testify in your trial. The state, the district attorney's office cannot force you to take the witness stand if you do not want to testify in your case. Now, the other thing is y'all can sit over here if y'all want to sit in. Now, as I mentioned earlier, you have a right to have witnesses to come to court to testify either for you or against you. And if you're representing yourself, or if you're represented by an attorney, they can be asked questions. We either call it direct examination or cross-examination. Now, you have a right to waive, which means you have a right to give up your right to have witnesses to come to court. And by doing so, you will not be calling any witnesses. However, the state will be calling witnesses. And as I mentioned earlier, you have a Fifth Amendment right against self-incrimination. That simply means that you have a right not to testify in your case. The state cannot force you to testify against yourself if you decided that you do not want to testify in your case. Now, you also have a right to waive or give up that right, that Fifth Amendment right against self-incrimination. Now, if you waive or give up your Fifth Amendment right against self-incrimination, that simply means that you will be testifying against yourself in your case. Now, you also have a right to have discovery. Discovery basically means that you have a right to see the evidence that the state has against you, or the evidence that the state will be using against you. So you have a right to see witness statements, your statement. You have a right to see documents. You have a right to have to see the videos or hear audio recordings or any objects that they will be using in your case. You have a right to have access to that. Now, if you're representing yourself, you have a right to have access to it. Now, if you have an attorney, your attorney will have access to that information. We call that discovery. So those are the rights that you have regarding your case. Now, everyone that's here for arraignment, you were arrested and you spent some time in jail, and then you bonded out. You're out of jail either on a cash bond, which means you paid the full amount of the money to get out of jail, or you're out of jail on what is called a surety bond, which means that you paid a bondsman a percentage of the cash that was required to get you out of jail. You paid them a percentage of it, normally it's 10%, to get out of jail, or you're out of jail on what is called a PR bond, which is a personal recognizance bond, which basically means they release you from jail without you having to pay any money, and you were released under your own personal recognizance, promising to appear in court. Now, I said that to say this: every day that you spent in jail, that time can be used toward your punishment. So for example, let's say you spent 5 days in jail and you and the state have reached an agreement to settle your case for you to serve 5 days in jail. That simply means that you will not have to serve any more time in jail. Why? Because you've already served 5 days in jail. Therefore, you will be given credit for the time that you have already served. Now, if the state is offering 7 days in jail and you serve 5 days in jail, that simply means that you will only have to serve 2 more days in jail because you've already served 5. Now, every day that you spent in jail also can be used as credit toward your fine and court costs. Every day that you spent in jail, you will receive $100 a day that will go toward your fine and court costs. So, for example, if you spent 5 days in jail, that's $500 that can go toward your fine and court costs. So if you and the state have reached an agreement to settle your case for fine and court costs of $500, that simply means that you will not have to pay the $500. Why? Because you spent 5 days in jail. 5 days in jail is $500. Therefore, the fine and court costs will be taxed and retired, which means you will not have to pay it. Now, if they're offering fine and court costs of $700 and you would have to pay $200. Now, you will be required to pay the $200 on the day that your case is settled. Now, if you cannot pay it, then the court by law can do a couple of things. The court can put you on what is called a payment plan. So the $200 that you're required to pay, you could be placed on a payment plan, and you could pay so much per month until the $200 is paid off. Now, if you do not have the income to pay the $200, no problem, because the court can, by statute, Article 42.15 Texas Code of Criminal Procedure, the court can convert the fine and court costs to community service. And so for every hour of community service that you do at a nonprofit organization in the community, $12.50 will go toward your fine and court costs. So for example, if you work at a nonprofit organization for 8 hours in one day, that's $100 that will go toward your fine and court costs. Now, if you have not been in trouble, this is your first time getting in trouble. Well, Jefferson County District Attorney's Office has a program that is called pretrial diversion. It's for first-time offenders. What they will do is they will dismiss your case, and you can get the charge or the offense wiped off of your record. We call it expunction. Okay, you can get it expunged from your record. Expunction means erased, deleted, or wiped off from your record. Now, in order to qualify for pretrial diversion, as I mentioned earlier, you can't have a criminal history. You have to get an attorney to help you to get in the program. And the other requirement, it cannot be for an offense involving unlawfully carrying a weapon or resisting arrest. For all other charges, you can qualify for pretrial diversion. Now, if you are a veteran of any one of the branches of the United States military, Jefferson County District Attorney's Office also has a program that is called Veterans Court. It's for veterans only. They will dismiss the case. You complete the program, you can get it expunged from your record. Only requirements is you have to be a veteran of any one of the branches of the United States military. Now, this court, Jefferson County Court at Law No. 2 has a program that I started within the first 100 days of taking office. The program is called a CSI program. It is a program that is designed to address the issue of recidivism. Recidivism basically means that people commit crimes over and over. And so how do we address it? Well, we address it through the CSI program, which stands for Community Safety Initiative. In that program, we have partnerships in the community. One of the partnerships that we have is with Spindletop. Young people that I introduced to you earlier, they're from Spindletop, and they're going to come to you in a few minutes and tell you a little bit about that program. But basically what Spindletop will do, they will do a private interview, then they will do an assessment, and they will develop a treatment plan for either outpatient or inpatient treatment. Now, you do not have to be insane or incompetent to participate in the program. They can address issues such as anxiety, depression, schizophrenia, bipolar, a whole host of other mental disorders, post-traumatic stress. And so those programs that Spindletop will be able, those issues that Spindletop will be able to address, they're going to talk to you a little later about what they're able to do for individuals who have mental issues. The other thing is Spindletop also has a program that is called ATAR. ATAR stands for Addiction, Treatment, and Recovery. And our local Drug and Alcohol Council has a program that is called OZAR, stands for Outreach, Screening, and Referral, Assessment and Referral. Those two programs are programs for individuals who have issues with drugs and or alcohol. And what they will do a screening, an assessment, and develop a treatment plan, either outpatient or inpatient treatment. And you'll be referred to the proper facilities if you are getting outpatient or inpatient treatment. If you are unemployed, do not have a job, or if you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in one of the areas that you select, they will assist you at getting a job in the area that you're trained in. Now, if you have not graduated from high school, well, CICE has a GED program. With that program, you could get your graduate equivalency diploma. And then once you get your graduate equivalency diploma, then you can be trained in those areas that I just spoke of. Now, all of those programs that I just spoke about are free, does not cost the county anything. Only thing that you have to do, and it doesn't cost you anything as well, only thing you have to do is take the time to participate in the program. And I tell people this all the time, when you come to county court at Law No. 2, we do not have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And we're trying to make a difference in the community in which we live, which is Jefferson County. Now, in this court, we do not just give time, we take our time. How do we take our time? Because we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And we believe that if we produce productive people will not commit crimes. Why? Because they have too much to lose. So if you're interested in any one of these programs, just let us know. And we have brochures and with information that will help you to contact the proper person or persons that you need to contact. Now, at this time, we're going to have Deputy Hinton and Ms. Leggington, who's going to come forward and tell you a little bit about the program that they have to offer at Spindletop.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve, and I'm a mental health deputy licensed by the state. I'm commissioned for the Sheriff's Department. This is my coworker here, Gabby. Gabby is a qualified mental health professional. The reason we are here this morning in this courtroom is the judge cares about every single person comes before the bench. What the judge has found, well, statistics prove is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources. The judge believes if he can help you with these underlying issues, he can get you out of the cycle of arrest. Now, maybe this is your first time to be here. Maybe it's your 20th time to be here. There's still hope. This program has the ability to change your life. So we're going to need something from you. We're going to need you to share that need with us. Now, when we first came in, Gabby handed you this form. It is a demographic form. It kind of explains a little information that we need to help you. And she's going to tell you what she will do with that form once you turn it back into us.
So this serves as a baseline efficacy. This means that this is protected just like the medical records. No one else is going to see this except for us. This also allows us to contact you once. So no matter if you're choosing, it can be text, calling. You'll indicate it on here also, but this also allows us, if you want to interview today, if you're feeling anxious or anything, you just want to talk to one of us, you can also step in the back of the jury room and talk to you. We can only contact you once. If you want to continue to be contacted by us, you can do so also. If you want to talk to us today, you can indicate that on the bottom. It won't interrupt any of the time. The court won't be longer. We work around. We don't want to add any more spots. We just want to help.
Also, before you leave here today, I want to give you this flyer. It tells you a little bit about the advantages of the program on the back, but also on the front, it has a 1-800 number. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. And just shortly, the court is going to go into recess. When they do, Gabby and I will be out in the gallery. We'll be able to visit with you. We'll answer any questions you have for us. Again, this will be private. And then we'll also pick up those forms for those who choose to turn in and participate in our weeks as well. Thank you. Very kind. Thank you, Your Honor.
Okay, thank you, Deputy Hinton and Gabby. And just for the record, Gabby, this is her first day with Spindletop. However, she was previously with Spindletop as a student at Lamar University. She just graduated a few weeks ago from Lamar University, and Spindletop hired her. Okay. And the other thing is, if you need any help with the paperwork, we have our court personnel who's here who'll be happy to help you with the paperwork. Now, we're going to go into recess for a few minutes, and I see Reverend Roberts here. He's with Save Our Children in, what is it? Save Our Children? Children in Motion, Incorporated. And he's going to have a program coming up pretty soon, July the 12th. And that program is Know Your County Courthouse. And he's been doing it how many years now? 16. 16. Wow, man. I'm getting old. I remember when he first started. Okay, so he's gonna be here in July with that program. It's a very good program where individuals come and learn about the courthouse that is in Jefferson County and what goes on here in Jefferson County. And so he has when he says posse, I says those who work with him, his board. We're happy to have y'all here in County Court at Law Number 2. And I tell people this all the time. Anytime you're in the area, please come and have a seat in County Court at Law Number 2. Now, I know when you came here, you probably looked up and you said, oh, that's Judge Holmes' courtroom. No, this is not my courtroom. This is your courtroom because I'm only a public servant who's serving the citizens of Jefferson County. Now, but as I mentioned, if you're in the area, please come have a seat in your courtroom. Now, that area that you're sitting in, we call that the peanut gallery. But it doesn't mean you can bring peanuts up in here and eat, because this is not the Texas Roadhouse. But you can come and have a seat in that peanut gallery and see what goes on in County Court at Law Number 2. So at this time, for those of you who are here for the arraignment, this is going to take a little time for us to pick up the paperwork and to go through all of the information that's on that paperwork. If you need to use the restroom, the men's restrooms is to the right of this courtroom in front of County Court at Law Number 3, and the women's restroom is on the opposite side of the hallway in front of the 172nd District Court, which is Judge Templeton's courtroom. So at this time, the court will be in recess. And before we do that, I'd like to thank everybody for coming out.